This
not a
this is
violation.
this is
It's not a violation
this is
of the lease.
ridiculous.
One mistake, just $79. That's all it took to turn this courtroom into a battlefield. Today, the judge isn't just handing down a ruling, she's delivering a reality check. And trust me, it's brutal.
No, it is simply what your argument is ridiculous. Town Center Place versus Jacqueline Kane. She can have a seat there. All right. This is your motion.
Your Honor, we request, per COD, that Ms. Kane be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she had, been looking for new housing. I provided a letter from Ms. Little from Housing Europe for Seniors showing the, properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then even after she has her interview, there's no guarantee that the apartment will be ready in a certain time.
The judge enters, and so does the tension. The defense is fighting for more time, 30 extra days for the tenant to move out. Why? They say she's actively looking for housing. Letters, applications, even some acceptances. It sounds promising, but when the judge asks, "Where's the interview date?" the room goes cold. No answers, no dates, just promises. In court, hope without proof isn't strategy, it's stalling, and the judge knows it.
And I also filed a
So when are her interviews?
Would you mind if Ms. Little comes up?
Yeah. That's fine.
Take the name of the record.
Okay.
So Ms. Kane has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet because there's still some paperwork. It's a really long process to get all of this done in such a short time frame, honestly, to get everything done. And so I would think the interview would be next week or so. She just needs to get down there and get it scheduled. I mean, the apartment that, have the biggest lead on isn't one we really want her to go to, because obviously in this short time frame, she's not gonna get a great option to move into. So it'd be nice if we got her from the others, but we'll probably have to.
Okay. All right. Thank you. Response.
We're asking, for a written for the conditional order of dismissal to be enforced. Part of the conditional dismissal order was that she paid rent, she paid full rent, she paid timely rent. And we've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And
The tenant's lawyer explains she's been accepted at 3 apartments, but no interviews are scheduled yet. Paperwork delays, tight timelines, and limited options make it worse. The best apartment lead isn't even ideal. It's clear. They're hoping for a miracle move, but the judge isn't sold. She wants facts, not wishful thinking. If this delay isn't backed by hard proof, it's game over. The tension in the room just turned into pressure.
she was supposed to pay on time, full amount of rent stated in the conditional dismissal. She has not. She's been informed that she had been paid by a letter paying less both times, and she has not submitted any extra money.
Okay.
Yeah.
Your Honor, the ledger that plaintiff added, submitted with their answer is not the ledger that they seem to have removed all of the hat payments and Ms. King's credit, and produced this ledger that they claim is what she has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been.
Now the plaintiff's side strikes. They say she broke the agreement, late rent, and not even the full amount. She owed $270, but paid only $247. That leftover $79 might seem small, but in subsidized housing, it's everything. One small crack breaks the entire deal. Rules are rules. The court isn't interested in excuses, they're interested in enforcement. And right now, the math isn't adding up for the tenant. The case just turned serious.
In this new apartment for,
When was she recertified?
She was recertified.
I think it's in April or March.
It was January 16th, 2025.
January of this year
Yes. The effective date was March 1st, 2025.
of the rent. So it's March and April. That
And
Go ahead. Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as a.
I recall. I
Did
recall.
that. So before that date, shouldn't be in controversy here.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, supposed to be February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had had since.
She was to zero out, that's what was supposed to happen.
Okay. So she gets zeroed out the credit that she has and the payment that she made for February? Because if you look back to prior to them filing this case, she had been paying $200.
I'm not relitigating the case.
Okay, well, Your Honor.
Things get murky fast. The defense claims the plaintiff manipulated the ledger. They allegedly removed credits and altered records. The court had ordered the ledger to be wiped clean. But somehow, the new document still reflects a past payment, and none of the credits you're supposed to keep. Is this a clerical error or a clever move to strengthen the eviction? The judge leans in. This isn't just numbers anymore, it's trust.
The COD says that she abide by the terms of the lease. This is subsidized housing. Paying rent late, which she didn't do because she paid on the 5th, and they didn't process it until the 6th. And not paying the full amount of rent is not a eviction cause for subsidized housing. They are required to offer payment arrangements. The goal is for subsidized housing.
She entered into a COD that she was going to pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different
All right.
time. And
This is ridiculous.
Back and forth they go. The tenant actually has the $79, but she won't pay it because she says the housing office still owes her credit. According to her side, they're charging her again for something she already paid. It's a standoff. The judge's patience is wearing thin. It's no longer about dollars, it's about compliance. And this courtroom is running out of second chances. What seemed like a small issue now feels like a mountain.
It is simply what your argument is ridiculous. Because what I'm going to do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm going to deny the motion to extend the time.
Your Honor, thank you.
Yeah, how is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time.
It
or the
does.
full amount. It does.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever, it lists the things that you can terminate. Do you have?
I'm sorry. Your Honor,
Yes.
the second line from the last line says defendant will pay March and April rent at normal time. Your signature is right here.
And she paid on the 5th.
She did not pay her full rent, ma'am.
Okay, but she paid on the 5th.
She didn't pay her full rent. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this.
So Your Honor, we'll submit a writ.
Thank you.
Thank you.
And then boom, the judge snaps. Your argument is ridiculous, she says. She calls it, the tenant failed to comply. The rent wasn't paid in full, on time. Housing wasn't secured. The ledger's a mess. Motion denied. Not once, not twice, but 3 times. No more debate. No more appeals. Just a cold, hard ruling. The defense pushes back, but it's too late. In this courtroom, clarity wins, and they just lost the case.